Hi everyone. Thanks again for joining today's Bench to Market talk around intellectual property strategy. It should be a great talk, and this session, as you just heard, is being recorded, so we'll be able to provide a copy of it following the talk. So as an introduction, hi, my name is Courtney Law. I am the new Managing Director for Biolocity. I recently joined in the last month or so, and so I'm very excited to have you all here today, and I look forward to meeting you once we're able to meet again. Just want to share a couple of high-level talking points before the talk begins. As you know, this is a part of our Bench to Market series. We have 6 more for the rest of the semester, and you can see the schedule. It looks like a pretty exciting schedule coming up. You can register for any of these talks at our website, biolocity.org. But I do want to highlight that our next talk is February 17th. The topic is FDA strategy with Richard Demonda. Also, I want to announce that our Biolocity RFP for the funding cycle is now open. If you are interested in receiving some commercialization funding from our organization, please schedule a meeting before February 19th. You're able to schedule a meeting by just going to our website and scheduling an initial consult. To be a part of this funding cycle, it's by invitation only, so you do need to have that meeting scheduled before February 19th. Another way to engage with Biolocity is by participating in our BARDA Drive Regional Accelerator. So we are one of 13 groups across the nation that work with the Department of Human Health and Services to connect the NIH with promising technologies and different priority areas of interest. If you're interested in learning more about what those interests are, how to engage with the NIH and the Department of Human Health and Services, please again, come in for a consult or feel free to email me and we can get you connected. A timely message for this talk and actually following our last talk is to let you know that Biolocity is offering legal office hours in partnership with the Emory School of Law and Nicole Morris. There are a wide range of areas of discussion that you can see on this slide. These meetings are by appointment only, and so if you go to the website that's listed on this website, you are free to schedule a free meeting with Nicole and her team. And to get to today's talk around intellectual property strategy, today's talk will be presented by James Rains, who is a professor of practice here at Georgia Tech. So I will turn it over to him. I do want to acknowledge during the Q&A, we will have 2 special guests to also join James to answer any of your IP questions. Our guests are from the OTT, or the Office of Technology Transfer offices, both at Emory and Georgia Tech, Doctors Nikosha and Bray. And so I will turn it over to you, James.
All right, I'm gonna screen share. Okay, welcome everybody. I'm just gonna get it started here in just a second, get my screen share going. Thanks for the intro. I am James. I work in the BME department here at Georgia Tech. My background is I worked in industry for several years. I worked at Stryker, worked at Smith & Nephew, and part of my job was IP management and developing new technologies. I've been at Georgia Tech here for 8 years now, and I run the Capstone program, and I work with a lot of companies and clinicians and helping them to develop new solutions to unmet clinical needs. And so today I'm going to talk at a high level about intellectual property, because you probably have a great idea, and I'm just going to give you some things to consider for your next steps so you can evaluate the intellectual property position as well as your strategy moving forward. And like Courtney said, we are lucky to have Terry and John here as well. I think they're going to try to answer questions during the presentation, but at least afterwards as well. All right. So just start off with the basics. What are the different types of intellectual property? Well, when you look at the iPhone, there's a lot of different types. You have patents, which is what most of us are thinking of. Then there's trademarks. There are copyright, as well as trade secrets. And when you think of the iPhone, there are probably hundreds of patents that they have tried to get. There's things around the shape of it, how it looks, the display screen, the circuits that are in there, the antenna, the battery, so high tech as well as visual, so the design of it as well. So they have patents around those. So as the trademarks, they're things like Apple, iPhone, iOS, so they're trying to protect their intellectual property, right? Their brand that they have created. Then there's what's copywritten. So there are things such as the ringtone. They develop these unique ringtones and they want to own those rights so that other people are not replicating it. And as far as trade secrets, what trade secrets do they have? Well, we don't know. They keep it as a secret. But I'm guessing it's something around like how they manufacture certain things, such as the glass, because they want to make as strong a glass as they can to prevent it from breaking. So these are the different types. Today, we're really going to talk about patents, but I wanted to give a high level on trademark because it's just kind of interesting. But when you think of Apple, and you think of the product that was created or the company that was created, and you think of the brand and you think of the Apple logo. And so when Apple came out a long time ago, they had Apple as a logo, but that's not the logo you're thinking of, right? You're thinking of a different one. Well, this is actually the first Apple company. And some of you may recognize it, that it is different than the other one. Well, these are two different companies, actually. The first Apple company was the recording company created by the Beatles. And so they had a company, they had established it. And then later on, this computer company started and they were Apple as well. And they actually, the Beatles sued Steve Jobs and his company for the naming rights. They were saying that they were infringing on their trademark. And they actually settled it out of court. They settled it and Apple agreed, the computer company agreed to not get into music so that there would be no confusion. And so obviously that didn't last, but just a few decades and that got revisited again and they had to come to another agreement. So anyway, trademarks are very important to people. Most of you are probably not going to be thinking about trademarks right now. You're going to be thinking about patents. And so when we talk about patents, there's really two main types that most people deal with. There are some additional, but really the main one, when you're thinking of a patent, you're thinking of a utility patent. And so that's the one where you're trying to protect like a process, a method, some kind of product solution that you have come up with, or maybe a way to manufacture something or a composition of matter. Those are what most people are thinking of when you're thinking of a patent, okay, is a utility patent. Now, there's also a design patent. That's when you're trying to protect the look of something. So those are usually like consumer products, clothing, things like that. Most of you are not really interested in that. You're really thinking of utility patents. So my conversation is really going to be about utility patents. But I always make a point about this. Just because you have a patent, that does not mean it is of value. So there are a lot of patents that are out there, and the USPTO office will tell you that less than 10% of them actually have commercial value. Here's a patent on the method of swinging a swing. And so I don't think that this one's really that valuable. I don't think they're making much money off of that. So you have to be strategic about what you are getting a patent for. So having a non-valuable patent is really just wasting money and wasting time. So you want to make sure you are protecting something that is of value and something that is of use. So different patents that are of value, do companies think it's important? Absolutely. So this product came out, Da Vinci came out with a product not that long ago. It's pretty good. They're very proud of it. But who wasn't excited about that product was Ethicon. Okay. Ethicon did not like it because they felt it infringed on several of those patents. And so they took Da Vinci to court. And so they are litigating that matter. So when you do have a patent, you do want to protect it and you want to make sure other people are not infringing on it. And that can be a costly endeavor. So that's something you also would have to consider in the future. Just as a frame of reference, at a minimum, you're going to be spending like $2 million in patent litigation for an infringement case. So it's very, very costly. But you are at a position now, you have an idea. So what do you do now with regards to intellectual property? Well, the first two things that you're really going to do is you're going to evaluate patentability and then the freedom to operate. So those are the two things, and we're going to talk through what does that mean? Patentability, we'll start with that. Okay, patentability, that just means what's my ability to get a patent on this idea. Okay, the second one, your freedom to operate, is basically saying, am I going to get sued, right? Am I putting myself in a position where I potentially could be sued? And you don't want to do that. So the first one is around, can I get a patent? And then the other one is, am I going to infringe on somebody else's patent? Okay, so we'll go through in a little bit more detail. So how do you figure out if you have the ability to get a patent? Well, you need to look at everything to see, has your idea ever existed before or something very similar to your idea? So you do a prior art evaluation. And when we talk about prior art, we're not talking about just patents. It's not just granted patents or just patent applications. You're looking at everything that's ever existed. Because maybe in another country, they had a product that wasn't patented, but it was sold. So you need to look really at everything. So that's patents, marketing literature, competitive products everywhere, not just in the United States, because it needs to not have existed anywhere. You need to look at research papers. So did somebody develop an idea just for research purposes and then they didn't actually commercialize it? You still need to look at that. And then patent applications. And then lastly, just searching the internet. Just see, is it out there? So you want to scour the earth, okay, to see, does it exist? Because legally, when you file for your patent application, you have to disclose what you came across as far as prior art. So this is a good first step, is look at everything. And then when you go to file at the patent office, there's a patent examiner. This is the most famous patent examiner that I know of, which is Albert Einstein. And they are going to look at three things for the patent. They're looking at, is it novel? Is it non-obvious, meaning somebody skilled in the art would not have come up with this? And then the last one is usefulness. They don't really evaluate the usefulness as much. It's really, is it novel and is it non-obvious? Those are really the two main things that they're evaluating. And one of the examples I wanted to cover with regards to patentability is you have to make sure you didn't disclose this publicly. So Dippin' Dots, we're all familiar with Dippin' Dots when you go to the football games or the basketball games. Well, when they created that, that guy got a patent on it. So he got a patent on the process for how they make Dippin' Dots. And they were on the market, and next thing you know, Mini Melts comes on the scene. And Mini Melts is very similar, looks the same kind of product. And so Dippin' Dots did not like that. So they sued Mini Melts. Well, Mini Melts fought them, and they were able to actually invalidate Dippin' Dots patent. Well, how did they invalidate it? They were able to show that Dippin' Dots actually were selling their product before they filed for that patent application. So they actually had commercialized their product. They were taking money for their product before they filed for the patent. So they had publicly sold their product, which meant they were not able to get protection around it. So you need to make sure when you are going to be presenting work, trying to publish the work, or talking to people about it, you got to make sure that you're protecting yourselves. So for public disclosure, once you disclose it, you now are starting a clock. You can get US protection for 12 months and you lose your international. So you need to make sure you are getting protection. So you want to work with John or Terry, whoever you're working with, you want to make sure you're protecting your ideas before you disclose them. Now, when it comes to freedom to operate, that is when you are looking to make sure that you are not going to get sued or you're not going to infringe somebody else's patent. So in this, you want to look at all the active patents that are out there, okay? You're looking for the independent claims that are in that patent. You want to make sure you are differentiated from the independent claims, okay? Don't, never, and I'm sure John and Terry will agree, don't ever write anywhere that you think you infringe a patent, because it could come up in court and you are not an attorney, you are not a judge, you cannot make that determination. Really, that's court has to determine that. So you can always tell your attorney that you found something of interest, but you never want to say that you infringe something. My boss has a great story where he had to sit in court and read the email that he had written. He had to read it out loud about how he thought they infringed a patent, and that did not look favorable upon them, apparently. But when you're doing freedom to operate, you're really just looking at active patents, okay? You're not looking at patent applications, you're looking at active patents. And once a patent is active, it's only alive or active for a certain time period. So if you were working on a time machine, this is an example of, if you came across this, you wouldn't need to worry about it because it's just a patent application, okay? But if you came across something that is a granted patent, so this one is an example, it was granted in 2004. How do you know if it's still active or not? Well, it's simple math. You take the earliest filing date, which is down here in 2001, and then you add 20 years. So that is how long, for most cases, that is how long a patent will have a life for, is 20 years from the earliest filing date. Okay, you can get extensions and things like that, but I'm not going to cover that. But that's just a good rule of thumb to know, is from when you file it, the life of it will be 20 years. And when I talked about independent claims, well, how do you know which ones are the independent claims? Well, you go, the patent claims are in the back, you go and you look at it, and you will see, like the first one is an independent claim because it stands all by itself. And then you look at the other ones, well, the other ones reference the first claim. So they depend on the first claim. So don't focus on those. You should focus on the first claim. I always say, let your attorney worry about the dependent ones. You just focus on the independent ones. And you need to make sure that you do not fall within that entire description in claim one. Okay. If you differentiate in some capacity, then that's good. Okay. For differentiating. But you need to look at all the independent claims of a patent and make sure you're differentiating. So now that I've covered the two main things, patentability and freedom to operate, we're going to go through a case study. So now let's say you are an engineer and you're working at a design firm, and the boss comes in and says, we need to design a new razor because Gillette is killing us. They have taken over the market. They are now 81% of the market, and we've got to do something about it. They came out with a Mach 3. It's got the 3 blades on there. They are destroying us. So you get the team together. You're going to start brainstorming. You're starting to work. You're coming up with ideas, and you guys figure it out. You guys figured out that you're going to do a 4-blade. So congratulations on the great idea. Now that you've got this idea of doing a 4-blade razor, what are you going to do? You need to do your patentability, and you need to do your freedom to operate. So for patentability, if you remember, you got to look at everything. You're not just looking at patents that are granted for razor blades. You've got to look and see, did they sell this 50 years ago or 100 years ago? Do they sell it in Europe, something that has 4 blades? Do they sell it in China? So you're looking at marketing material, you're looking at advertisements, you're looking at publications, you're looking at research, you're scouring everywhere to try to figure out, is this a novel idea? Has somebody else come up with a 4-blade razor? So you do all this work and you found out that nobody else has ever done the 4-blade. Congratulations, you actually were able to file and get a patent on the 4-blade. That's fantastic. That means you were able to patent your idea. So now the next phase is, will I get sued? So you need to go and look, and you're not looking at everything. Now you're just looking at the granted patents. So a good way to start, I always recommend, is to go to Google Patents, Advanced Google Patents, and just start searching in there. And when you put something in there that's pretty broad, you're going to get a huge result. So you may want to narrow it down in Google Patents. They will let you narrow it down by granted patents versus patent applications, and that's going to narrow it down quite a bit. You can also look by who the assignee is, and the assignee is the company or the entity that owns that patent. So if you know Medtronic or Boston Scientific, if you know they have participation in a space or their big competitor, you may use that to help you narrow down some of your initial searches. Okay, it's not exhaustive because you have to be careful because sometimes they don't use the name Medtronic. They'll use a different name. They may have a different holding company like SDGI. But it's a good starting point is to look at who the assignee is. And you can look it up, but make sure you're looking at the granted patents when we're talking about freedom to operate. So you can go and you can look, and it'll narrow that search down quite a bit. So if we did this for razor blades and we found it by Gillette in the granted patents, we're really going to narrow it down. And we can find a relevant patent like this one. So it is granted, but the first step I need to take is to figure out, is it still active or not? And so I look at the date of when it was filed. It was filed in 2005. And so I do the math of adding 20 years, and then that should give me 2025. So that means it is still active. So it is one I need to take seriously. So if it had expired, then I wouldn't even worry about it. But this one is active. So it's active. I'm going to go and look at the claims now. And remember, I don't want to look at all the claims. I'm just going to focus on the independent claims. What are the independent ones? Those are the ones that stand by themselves. So I go and I look and I see all the ones that depend, but I'm just going to look at the independent. So I read it. I go through. I'm just going to focus on it. And it says a group of a first, second, and third blade. No mention of a fourth blade. So congratulations, you guys, you go on the market, you release the Quattro, the 4-blade razor, and you're so excited. The company is so excited, but Lee Corso's not as excited. Why is he not excited about it? Because that patent claimed 3 blades. Your product has 4 blades, but 4 blades contains 3. So your product, though you did get a patent on it, it actually infringes another patent that is out there. Okay, so sometimes this point gets confusing. How can I get a patent and it still infringe somebody else? Well, your patent was an improvement upon another invention. So you can still get it, but you can still be open for infringing somebody else's patent. So it's to be clear about a patent prevents other people from practicing your invention, but it does not actually grant you the right to practice it without consequences. Okay, so you need to make sure, even if you get a patent, you need to make sure that you don't infringe somebody else's patent. Okay, and so to make matters worse, Gillette sued you guys, and you guys stayed in court just battling back and forth, and that's unfortunate. And then the salt in the wound was they came out with a 4-blade. So they just leaped right over your 4-blade idea. But anyway, the key takeaways here are patentability and freedom to operate, so that you know when you have a great idea, those are the 2 things you need to evaluate. Can I get a patent? And would I potentially be at risk if I commercialize my idea? Am I at risk of infringing somebody else's patent? Okay, it's important when you're looking at, when we talk about reviewing patents and worrying about the claims, make sure you know the difference between an issued patent and then a patent application. Okay, I see this a lot. I see people looking at a patent application and there are claims written in there, and you're limiting yourself based upon those claims that somebody wrote. But you have to understand, when people write a patent application, they are putting very broad claims in there. So those claims, I always say this, they're really just a wish. You have no idea if they're going to be granted or not. So you don't need to be constraining yourself to what somebody put in a patent application. Okay, it's interesting to look at the technology, but don't reference those claims because they mean nothing. They mean nothing until they're granted. You can go actually deeper into a file wrapper and find out how the status of the claims are when they're being reviewed, but don't waste your time reading claims of a patent application. Only granted patents. Okay, so again, this is like a patent application. It'll say patent application, and it has like a year in the title versus a granted patent. And so those are the difference. Another mistake people make is when they see these PCT, which is the international. When they see the PCT ones, people think that that's a granted patent. Okay, but it is not. It is an application, and you're trying to get additional patents from that. So just to cover the patent strategy, like I said, you have an idea, and you should be working with your person, either your representative in OTT at Emory or at GTRC or whatever institution you're at. You need to be working with them. But when it comes to protecting your idea, what's very common is for people to do a provisional patent application. So a provisional patent application is very inexpensive, and it basically holds your place in line. It's like a few $100s, and it holds your place in line from a priority standpoint. And then within 12 months, you have to file either a US or PCT application. And if you're just going to try to get protection in the US, then that's a path to go. You can do a non-provisional in the US, and that's going to cost you altogether around $25,000 or so. Or you can go for a PCT, which would allow you to get coverage in a lot of different countries, including the US, but it allows you to do international ones. And how much does that cost? Well, it depends, because for every country you're having to pay, and it's a different amount. Sometimes you have to get translations done. Countries do it a little bit differently. We have to pay an annual fee sometimes. So it really just different. It's just really different. But when you look at it, a provisional patent application does not have to meet the same standard as a non-provisional patent application. So you'll see sometimes people submit a drawing or a sketch with some description on there. But what's important to know is you're only protecting what you put in there. So if you're very high level and you don't really describe the enabling element about it, you don't really give the details of it, then you're not really protecting much. So it's just kind of a waste. You think you're protecting it because you say you have a tool to do X. Well, if you don't explain how that tool works and you're not providing some details, the components, the testing examples that you've demonstrated that it does X, then you're not really protecting much. So you're kind of fooling yourself a little bit. So make sure you're putting good content in there, because that is what you're protecting. Okay. But people may or may not do a provisional, which again is very inexpensive. And then once you start talking about real money and investing, tens of thousands of dollars, then you're starting to do a non-provisional. Okay. And that's when it looks more like a real patent. It's got official drawings. It's all in the same format. And so you can do a US or you can do a PCT. And the US one is just going to get you a patent in the US, but then the PCT allows you to get all these different countries. And again, it costs money for every country, so it can add up very, very quickly. And then the other thing too, people don't realize is that this is a very lengthy process. It takes years to get a patent. Sometimes you can get it done real quick, a year or so, but on average it's several years. Okay. I've had it take up to 10 years to get a patent. So it can be a very lengthy process. It's not going to happen as quick as maybe when you're thinking of like filing for FDA, a 510K, that happens in 90 days, you get a response. For this, it takes years. The last thing I wanted to say is when you're doing this work is be involved. Okay, that's my number one recommendation. Make sure you're being involved, working closely with your representatives at OTT or at GTRC. They want you to succeed, but you've got to help explain to them, because you are so in the weeds of the details, you've got to help explain to them what is of value about this. Okay. They don't have the same perspective that you do. So you need to help them understand what the value of it is. And same thing is once you start working with an attorney, if you're working with another attorney or an outside group, you have to help them understand what this value is. So make sure you are working very closely because these people want you to succeed and you've got to work with them. Okay. You can't just toss it over the wall and just expect it to all take care of itself. Okay. And the other thing too is it does help. They're going to be more excited about helping you file something if they do know who could be a potential licensee or if there's somebody who is interested at that point. Okay. So that's also very helpful too. All right. That is all that I have about intellectual property. Again, Terry and John are here to answer some questions. I did want to do a quick little plug for if you're an inventor and you're trying to make a company, you should read Bad Blood if you haven't already. It's about the Theranos story. It talks about patents in there and about litigation around that and how valuable are patents. It's very interesting. It's got some good war stories and about ethics too. It's really good. And I also wanted to do a quick plug for Leisha Lee. She is a great resource at Georgia Tech's library. She is like an expert in searching for patents. Okay, so she has like a special souped up search engine that can really help people. And she does training on doing patent searches. So you should look her up if you are at that phase. It's Leisha Lee, Lisha Li. So thank you very much. And I guess we'll open the floor to questions.
Yeah, so we got one question that came in on chat here that I started answering, but I guess we can just address that now. So somebody asked which countries you often see patent applications for once the PCT expires, and if the European Union accounts for sort of one country, or if that's others. And that's a great question. So when we get to the end of a PCT, usually about 6 months out, we'd want to be thinking about which specific countries we want to file that in. And mostly that decision is driven by market trends. So if we think that there's, a way bigger market in one country or another, maybe it's a larger patient population or whatever kind of your device is, that would lead our decision making towards which countries to file. EU is kind of an interesting situation because the EP, as it's called in patent lingo, is sort of one office that will examine a patent application for the entire European Union. But eventually, once we get to hopefully an issued patent in the EP jurisdiction, we'll need to choose individual countries in which to validate that application. So at each stage of these decisions, we'll have obviously be spending more and more money. But by the time you get to the end of that EP, we'll say, okay, do we want to validate that in France and Germany and Italy, or do we want to go even broader into smaller countries? So it mostly follows kind of a market-based calculation, I'd say. We also had a good question come in. You may have seen it on the Q&A start here. Someone said, for a startup then, it seems IP protection may not be a really good mode of competitive advantage. They mentioned that they had heard that there are often ways around a patent and that small startups usually don't have the resources to battle it out in court. That can be true. It's certainly daunting to go up against a large pharmaceutical company or something like that. But if you're a startup, and especially if you're focused on therapeutics or devices, where your path to a patent might be a little bit more straightforward than in the software realm, I still would say it's very, very important to at least explore filing a patent application. Potential investors will want to see that there's some way to protect whatever technology they're investing in. And so even in an early stage, if you have kind of a rough concept of something and you file a provisional application, that gives you a priority date, as we call it in patent lingo, to claim, all right, this is when I had this idea before anyone else did. And especially if you are before company formation and your IP is still sitting at Georgia Tech or at Emory, Emory is going to be the one, or Georgia Tech is going to be the one that's spending the resources to try to protect that idea and build out a really valuable patent application. And then when your startup company would license that into itself, then you would hopefully have, a pretty solid means of protection around it, and hopefully tons of VC dollars to help you defend yourself in court if it ever came to an infringement lawsuit.
Just to add on to that, I think IP protection is one of the first 3 questions you get when you are talking to an investor. And if they don't feel like you have something that's unique, that Medtronic, for example, can just swoop in and duplicate better, they can do it quicker, they can do it cheaper. If you have no protection around it to keep them away, then it's less attractive for them to risk their money going to you. Okay. And it is true when you're a startup, money is tight and it is expensive to do that. But as the wise sage Terry Bray told me when I asked him about this, he said that if you can't afford to file your patent, then you've got bigger problems at that time. Okay. So when you're a startup, if you can't afford that, then you can't afford the other things. So IP, while it does cost money, it is a small portion of what you're going to be paying for other things. And I still hold that, Terry. I hold that nugget with me.
Yeah, that's absolutely true. Terry, you might be muted in case you wanted to add something.
Okay, yeah. So I'm glad I said something that stuck with you, James.
And I'll add one other point on that, because I drew kind of a distinction between software-based technologies and therapeutics. There is an interesting strategy that some software-based companies use where instead of trying to file for patent protection, if they're in this realm where maybe the patent office might consider it to not be a patentable invention, depending on the type of software, it could be a better strategy to instead pursue copyright protection of certain pieces of software. And one reason for that is that you don't have to disclose everything that's protected by copyright, unlike in a patent where you're really going to have to give away your secret sauce. A way to think about patents is the government is kind of granting you a limited monopoly on whatever they end up issuing you in a patent in return for teaching the rest of the public about your invention, so that when your patent expires, in theory, then anyone else could practice that invention. So some companies that are software-based really don't like dealing in patents because you're kind of giving away a lot of how your algorithm works or something like that. So if you instead protect it by copyright, you can keep the rest of it a little more secret, and sometimes that's more valuable for pure kind of software-based technologies.
Kind of another example of that would be Google, right, with their search engine. That's so valuable to them. They would rather keep that as a trade secret than try to disclose it and get patent protection. But I will say, what I'm sharing is, that's my opinion. It's my advice. I know there's Chris Lee is an example, right? He will get up here and probably tell you that there's not much worth in patents, okay? Because it's so easy to work around. So it's a case by case, and you got to look at what you're going after and how novel is your idea, and is it really worth the risk? But he would probably discourage you for getting a patent, and he's been very successful with his strategy. So I'm not saying it's wrong. I'm just saying another consideration would be to look at whether you think it's of value to protect your work.
Absolutely.
All right, talk about filing, the cost of filing. Do you guys probably have better of the financials. I can only talk about it from a customer standpoint and the checks that I write.
Yeah, sure. I'll say a general rule of thumb, at least from our experiences, the cost to file, there are set fees set by the patent offices that we don't control, and they are what they are, both in the US for a PCT application or for other individual countries. The cost to actually write a patent, respond to office actions really depends on the complexity of those activities and how much attorney time is required. I would say the general rule of thumb I always tell people is the total cost to file a patent and prosecute it to issuance in the US is typically going to fall within the $20,000 to $30,000 range. Sometimes, you'll have some outliers around that, but that's a pretty good range where most of the patent filings we see would fall. If you file PCT and then you start electing into individual countries, then it gets quite a bit more expensive because each country has its own patent system, its own fee structure. So if you file in 4 or 5 countries, you're probably going to be exceeding $100,000 pretty quickly. And if you file in, not too many more than that, you could be in several hundreds of thousands of dollars from start to issuance. So patents can be very expensive, but if the idea is platform, if it's novel enough, it may be worth that investment.
Yeah, and so that's a great answer to that question. Another question that came in is for therapeutics, are new indications or repurposed use for an existing treatment patentable? And I guess the short answer to that is often. Sometimes we'll have investigators that are exploring an existing drug and they say, okay, well, I think it might be useful to treat this other disease. And I think what we've seen a lot of times is patent examiners may look at sort of how close those two diseases are to each other. So if they share like a really similar mechanism of action, say it's another TGF-beta inhibitor for pulmonary fibrosis or something like that, it might be a little bit of a tougher sell because even though it might be a different disease presentation, it's still kind of really similar underlying biology. So that might be a little bit of a higher bar. But if you have something that is, a different mechanism of action, nobody knew that a drug hit this pathway or whatever it is like that, then that really often is patentable. And those can be really valuable patents because if the licensee is the company that made the drug for its primary indication, and they see, hey, someone at Georgia Tech or Emory figured out that it could be used for this other thing, and we were able to get patent claims around that, then that's a really quick path to market because we already have regulatory data on that. There's already approval in one indication, so we have a good indication of safety and toxicity, and we can just kind of hand them this new indication on a silver platter. So that can often be a great way to, or a quick path to market.
The only thing I will add to that is if you come up with a new indication, say there's a compound that's been shown to have efficacy for treating lung cancer, and someone discovers that it also appears to have efficacy for psoriasis. Okay, that's a completely different indication. And as John said, you probably can get a patent around that. The issue will be, though, who owns the composition of matter, right? So if there's a company that has existing claims around what the compound itself is, and those claims are still valid, really your only licensee is the company that owns that compound.
So someone asked, how many patents do GT and Emory file in a normal year? I'm pulling up some of Emory's numbers now. And it's, I think, in fiscal year 20, let's see, we filed little under 200, it looks like. So I'd say that's maybe a little lower than that. I think maybe closer to 150 and that's including, provisional applications that are, brand new, and then converting those to a non-provisional, which would be either a US application or a PCT, like James mentioned. So it's somewhere in that range. We've been kind of close to that number for the last few years, but around there.
Yeah, we normally file around 200 provisional applications. I think we filed 230 something last fiscal year, and we normally convert roughly 100 plus or minus a little bit.
Yeah, so that's a good point. Oftentimes we'll file a provisional on something, sometimes before we really have a good chance to take a look at that technology and see if there's anything patentable or really valuable there. Sometimes our inventors will come to us and say, I'm giving a talk tomorrow, I've got to get something on the books. And in that case, we don't really have a chance to do a full analysis on that. So we can put together a very quick, what we might call a cover sheet provisional. And that gives us a year to do a little bit of a deeper dive on that technology and see if it makes sense to convert that into a full non-provisional patent. So it kind of funnels down as you get farther along in patent prosecution.
John, I find that hard to believe that they come to you at the last minute.
Yeah, never happens, right?
Well, if there are no more questions, I want to thank James, John, and Terry. James, of course, for your great presentation, and everyone for answering these fantastic questions. Before I close it out, do you guys want to share the best way to contact you or your offices? Sure,
absolutely. So Emory OTT, we have a website on Emory's website here. It's just ott.emory.edu. Our whole directory is there. You can also reach out to me directly if you look me up. I'm on LinkedIn, I'm on Emory's directory, and I'd be happy to follow up on any IP related questions or, tech transfer in general. I know it's kind of a mysterious world if you've never interacted with us before. So I'm happy to chat with anyone.
Yeah, likewise, we have a website where me and my whole staff and our contact information is there. So feel free to find us and reach out, and happy to answer questions, on what we do specifically at Georgia Tech or just tech transfer in general. As John said, it is a little bit of a mysterious field if you're not in it. So we're always happy to have those conversations. I guess just one other thing I would say is for those of you who are affiliated with universities and you come up with a a eureka that you think is an invention, please reach out to your tech transfer office sooner than later, just so we can have a conversation, see if there's something we need to protect and not have these last minute disclosures where we have to react very quickly because you're about to get on a plane to go give a presentation.
Or jump on a Zoom link.
Yes, or Zoom link in today's age. Yeah.
If anybody wants to talk to just somebody, an inventor who's done it, turned it into a company, and just the war stories that go with that, I'm happy to talk to people. And I don't have a fancy website like you guys. I'm just James Rains. If you look me up, James Rains and Georgia Tech, I'm the only thing that should pop up. So thanks for inviting us, Courtney.
Yeah,
we enjoyed it. I think it was good having the power team, having the experts on here. It was fun.
Absolutely.
Lots of
Well,
fun. Thanks, Courtney.
guys. I am definitely
Yeah,
going to
thanks.
invite you all again. And thank everyone, and thank you all for joining. Like I said earlier, this is recorded and we will share a link once we have it uploaded. So, and don't forget, our next talk is around FDA regulatory stuff on February 17th. All right. Bye, everyone.
Bye.
Yeah, have a good day.